over your face. Throw an elbow.
Hi everyone, thank you so much for joining us today. Today is an extra important video and it touches pretty much all of you out there. So I want you to pay very close attention, and at the end we're going to have a special giveaway for all of you that will stay till the end. So stay tuned. Before we're going to start, please share with our viewers and our audience a little bit about yourself.
So as Rachel said, my name is Stephanie Rojo. I'm an estate planning and estate administration attorney at Stone Law Offices in Northwest Las Vegas. I am a Las Vegas native, born and raised.
Woo-hoo.
I am a mother of two beautiful children, been married about 8 years, going on 9 years right now, and I love estate planning. I love helping people put a plan in place for themselves and their families. And believe it or not, I actually do enjoy the probate process. I like to avoid it for clients if I can, but I enjoy the process with the courts. And I can also help clients with their trust administration, meaning when they have a trust but someone passes away or become incapacitated, I help the trustee transition the assets appropriately.
So Stephanie is going to talk about something that, in my opinion, it's crucial for each and every one of you to pay close attention, even take notes. And if you don't want to take notes, just go ahead and meet with her. So let's dive right in. Trust is something that not many people know what it means, and when they do know what it means, they much rather to push it back and postpone it till maybe one day I'll get to take care of it. So let's start. Tell us, what is a trust?
Absolutely. I'd be happy to answer what a trust is. So a trust is an estate plan. It's a legal document where you are identifying a trustee of your trust to manage your assets in the event that you become incapacitated or that you pass away. Not only are you identifying your primary choice for a trustee, you're identifying alternate choices as well for successor trustees in case that first trustee can't serve. You're also identifying what's going to happen to your assets. You're putting a plan down on paper for specific distributions that you'd like to have made. You're putting who your ultimate beneficiaries under the trust are going to be, and you're identifying how those beneficiaries are going to receive those assets from you. You're also listing contingent beneficiaries. So if something happens to one of your beneficiaries, they pass away in an order that's unexpected, you've got a backup plan in place to say who's going to receive that if they can't. And then we, as attorneys, we do lots of layered planning, so we also have contingent remainder beneficiaries. So if there was a meteor on the family reunion and everyone was eliminated, would this go to a charity or a long-lost cousin, or do we just shake the family tree and give it to our closest living relatives? So at the end of the day, when you're talking about a trust, it's a legal document where you're putting a plan down on paper so that if you become incapacitated or you pass away, you have instructions in place when you can no longer make those instructions yourself.
I love it. Thank you. Another question that I have is, who actually needs a trust?
That is a great question, and I get that all of the time. I say anyone who's over the age of 18 who is starting to develop some assets of their own in their own portfolio, house, whether it's a retirement account or some type of savings, they could at least have a conversation with an estate planning attorney to see whether or not a trust makes most sense for them. Now, granted, most 18-year-olds don't have that type of asset portfolio that they're establishing, but we can still have a conversation and say, well, if a trust isn't going to work for you, maybe a will package or even just healthcare powers of attorneys. But someone who is just getting started in life, who is building some assets to their name, maybe they just got married, or maybe they have minor children that they want to account for and plan around, those are the type of people that I'd like to see in my office.
Okay. Now, is a trust something that you create at some point in your life and then just put it in the safe and forget about it, or forget about it? Or is it something that you need to revisit and check?
Absolutely. So a trust is definitely a document that you're going to want to stay on top of and make sure that it's current. So the industry standard is every 3 to 5 years you sit down and you meet with your estate planning attorney to do what we call a fire drill review of that that estate plan, where your attorney is walking you through, okay, what if something unexpected happened tomorrow? How is this plan going to play out? Who's going to step in and take over? And while you're thinking about it right now, are there any changes that you need to make? So,
Right.
life happens. There's changes in your circumstances. There's marriages, divorces, births, deaths. You can come into some money, or maybe your financial situation might change drastically in some other way, shape, or form. So we as estate planning attorneys want to make sure that we capture that information and we're accurately representing that in your documents so that your wishes are being met with those
Yes.
documents.
Now, tell us few horror stories of those scenarios that people waited and waited and waited, and then something happened to them.
Okay, so I think it's important to emphasize that getting a trust set up is the first part. The second part is getting your assets retitled into the trust. And a lot of people want to do that so they can avoid what we call in our industry the 4-letter word, but it's more than 4 letters, probate. Most people want to stay away from probate because it's a public process, it can be lengthy, it can be costly, and the horror stories that you're talking about, more often than not, are related to probate. They're related to situations where people did their own estate plan and messed it up, or they didn't retitle their assets properly to their trust and messed it up. And I can go on and on for specific stories, but let's just throw a couple out here for you. So these are true stories, but I'm changing the identities to protect the witnesses, not the witnesses, but to protect the folks in the situation.
Such a lawyer to protect the witnesses.
So I had a situation where I had a trust that mom had created. She was giving everything to her only son, and son was married. So mom passed away. We did the trust administration, got the assets over to the son. It was a couple of investment accounts, but there was a house. There was real property that came to the son. And I advised the son, hey, we need to get an estate plan set up for you, or at the very least, we need to retitle this from your individual name into your name jointly with your wife so that if something happens to you, we have a plan in place. Well, he was one of those people who wanted to kick that can down the road and save a couple $100, didn't want to move forward. Long story short, within a couple of months, it was completely unexpected, he passed away suddenly, and left his wife behind. She calls my office to let me know that he's passed and says his house is in the trust, right? He did estate planning with you. And I had to tell her, I'm sorry, but no, he didn't want to move forward. And I looked up the house, confirmed the title, and it was just in his name only. So we had to do a probate for this house that had already been administered in a trust administration.
Wow.
And now we're in a situation where the probate is over and the house is in her name, but she doesn't have any kids. She's no longer married. She doesn't really have any close friends or family, at least here, and it's going to take some investigation to find out who her closest living relatives are. So I'm really working on this person to encourage her to move forward with an estate plan to avoid having a second probate on this property when she passes away. Another example of a probate gone wrong is when we have a person who creates their own will. Here in the state of Nevada, we have something called a holographic will, where you can write out your own will yourself. Or
really? I didn't know that. Okay.
Or you can print out a do-it-yourself will online and get that signed and notarized. But if you're not putting the proper language into your document, or you are not considering these contingency plans that we talked about before, there's going to be some problems.
Right.
And with a holographic will, it's even more complicated. You think, well, I can save myself some money. I'll do the documents at home. I'll be done in 10 minutes. No problem. Easy peasy. Well, when you pass away, we actually have to get a handwriting expert to evaluate whether or not that's actually your will.
That's insane.
You wrote everything in your own handwriting. There's certain elements that you have to meet under the Nevada statutes. So that is a huge reason for probate, and you want to avoid that if at all possible because it can be pretty costly. I've seen situations where I've had outdated documents. Like last year, I probated a will from the 1960s. The woman had created the will when she was a young mother. She had a couple of children who were very young at the time that she created the document. And from 1960s all the way to where we are today, she never updated this document. So all of her executors were deceased and all of her children were now seniors. So the will itself was basically useless, except for the fact that we knew the children were going to get equal shares. So that was a little bit of a headache
Yeah.
to go through probate, and it didn't help when the siblings were fighting with one another to figure out who was going to administer the will with
Wow.
the court.
Can you tell us about the safe?
Oh,
Safe is a
yes.
story that you told me, and I was, what?
So safe deposit boxes can be extremely problematic if you own them in your individual name only. If you own them jointly with someone else, that's not as big of a deal, because if you pass away, you've got someone else's name on the title to that box. But if you have a box that's in your own name and you're just keeping papers, old postcards in there, tchotchkes type thing, you don't really have gold bars set aside or deeds to really important big pieces of property, you're going to want to think twice about having that safe deposit box. I know banks a lot of times they'll offer it as like a bonus or an
Yeah.
add-on. Hey, you've met this requirement with our bank, let us give you this free box. Well, those can actually have hidden fees on the back end when you pass away, because if no one else is on that box with you and it's not titled in the name of your trust, we actually have to get a court order for a judge to sign off on an order for the bank to allow your executor or your administrator to get into that box. And I will tell you time and time again, when we have to do that, we're just finding papers or a coin or two. It is nothing that would substantiate the cost of having to go through that special administration with a probate.
Wow. Wow. Another really important question that I have for you is, please tell us what's the difference between a will and a trust, because many people that I spoke with, they told me, oh, I have a will. I don't really not need to talk with Stephanie. So please explain what's the difference.
Okay, so the biggest difference between a will and a trust is that if you just have a will, when you pass away, your estate is going to flow through probate. You're going to go through that public process where a judge is involved, and we have different hearing dates, pleadings that need to be filed. Everything that's filed with the court is going to be made public. So you are still going through probate. You're not avoiding that by having
Okay.
a will.
Okay.
By having a trust set up, you are identifying what assets are going into that trust, and when you pass away, you're hopefully avoiding probate. And I say hopefully because not every time someone has a trust, they're going to avoid probate. You need to make sure that all of your assets are put into the trust in order to avoid probate. Probate is when you have an outlier asset off to the side that you did not retitle into the trust. And just to remind you, for some of those, for those of you who do have trust, you're going to have the trust and a will, because we want to have a catch-all document that says in the event that you
Right.
forgot to put something in your trust, we can take that to the probate court and get those assets pushed back into your trust, because your trust, once again, has that layered planning for what would happen if one beneficiary can't receive. It has that layered planning for who's the trustee going to be, who the successor's trustees would be, etc.
Is there any tool that you guys use to differentiate between like personal items and business items? Like, how does it work? If a person has a business or several businesses, and on this hand, and on the other hand he has all his personal stuff, what do you do with that?
So we definitely need to have that initial consultation with the client to discuss what exactly those assets are. Is there a business entity already set up? Or are they just kind of working out of the garage at this point, but they expect for the business to grow in the near future? So we have attorneys who specialize in business planning that can help get that plan formalized for you as a business owner. Most business owners are going to have a foundational estate plan in place. They're going to have a revocable living trust in place, and that is the type of trust that we've been talking about this entire interview. There are some businesses that would warrant having an LLC, like if someone has rental properties that they've purchased and they want to protect themselves from personal liability, from being sued if something happens in one of those properties. So we would get that LLC set up, and the LLC could either be owned by your revocable living trust, or there are other tools available like an asset protection trust. And I will tell you, we don't just jump into selling asset protection trust to our clients. We go through a complete analysis to see what exactly are the assets that you own. Are there any other protections that the Nevada law offers to you? And what total amount are we talking about here? And an asset protection trust can be an excellent tool or resource for the right type of client. And an asset protection trust is something that owns your assets, and you set it up in advance of creditor issues coming up. So if you already have creditor issues and you're trying to dodge those creditors,
You can't.
this is not going to work for you. But if you're anticipating maybe down the road there might be some type of problem and you would like to try to further protect yourself, you get an asset protection trust set up, retitle some of those assets into the trust. There's a 2-year seasoning period here in the state of Nevada, and you are giving up some control over those assets. Those are things we can talk about in more detail in a one-on-one consultation, but it is available to clients.
Okay, thank you for that. Let's say someone created a trust in New York, and now he's moving to Vegas. Is there any need for him to come with his trust and sit with a local lawyer to review his trust?
That is a great question, and I would absolutely recommend that if you are relocating from another state, that you sit down with an estate planning attorney in your current state of residence. So if you're moving here to Nevada from somewhere else, sit down with an estate planning attorney to walk through your existing documents, identify if you're planning to live here long term, or are we really talking about a snowbird situation where you're coming down for a couple of months. At a minimum, you are going to want to update some of your ancillary documents, like your healthcare power of attorney and your financial powers of attorney, because those are state-specific documents. So if you have permanently relocated from another state to the state of Nevada, you're going to want to get those documents updated. Whether or not the trust needs to be updated is a whole other question, and I have to look at the document to make that yes or no determination.
Yes. Thank you so much, everyone. Thank you so much, Stephanie, for joining us today. If you have any questions, feel free to leave them at the comments below. We will share them with Stephanie, and she will answer, or just go ahead and meet with her. Her office is beautiful, and you always get a really good coffee. That's it. Thank you so much, hon.
Thank you.
Over your face! Yare yare だぜ。Throw an elbow.